Good morning. My name is Attorney Andrew Popp, and welcome to this presentation as part of the 2021 Portage County Financial Wellness Fair. This morning, we're going to be reviewing the ins and outs of guardianship and powers of attorney as they relate to your estate plan. Well, let us pull up the screen share here. All right. Again, there's me. I'm Attorney Andrew Popp. I am a local attorney in Portage County. We have offices primarily in Ravenna and Stowe, although I routinely help people throughout Northeast Ohio. I practice exclusively in the area of elder law and estate planning. Part of the reason for that is that this area of laws became extremely complex, especially in the past probably decade or so. So in order to really be sure I know all the ins and outs for any of my clients, I focus just exclusively on this area of law. Now, when we're talking about estate planning and how things like powers of attorney and guardianship fit into that scheme, I think it was going to be helpful to at least get a very brief overview about estate planning generally. So when you're talking about an estate plan, what types of things do you consider? Number one is kind of the traditional view that most people consider when they're looking at building an estate plan. And that is you are trying to spell out what's going to happen with any of your things whenever you pass away. You have the document that everybody pretty much knows about called your last will and testament. That's where you spell out where you want your assets to go whenever you pass and who you would nominate to be the executor to actually handle all of that. The number one misconception that I hear about that document is simply that people don't realize a will requires probate. So wills make probate easier, quicker, and you have some control over what's going to happen, but you still have to go through the court process. Next on the list is a trust. Trusts act kind of as a will substitute for assets that are in the trust, and they do avoid probate. C, we have beneficiary designations. That's things like life insurance policies, retirement accounts, and the like. And then D is transfer or pay on death designations. The big things here in Ohio that we typically think of are things like your home, your motor vehicles, or if it's regarding pay on death, like a bank account, okay? Now there is an entire presentation on estate planning for as far as these aspects coming up later in the week. Today, we're going to be focusing more on number two here, which is the other side of estate planning, which is what happens while we're still around, but if you are incapacitated, okay? So it's things like deciding who can help out and make medical decisions for you if needed, who can assist you in determining what type of living arrangements you need to make, as far as if you need home health care, a nursing home, something like that. And then C, things regarding your finances, money management, paying bills, things like that. Things we consider when setting up an estate plan are any benefits you receive, whether it's something like Social Security, pension, needs-based programs like Medicaid or SSI. You want to make sure those are set up properly to ensure that you manage the way that you need whenever the time comes. Retirement accounts are the same way. And family dynamics. This is one that I think is overlooked by too many people. So what I mean by that is this. Everybody has their strengths and weaknesses. There's nothing wrong with it. It's just, simple reality of the fact. So not everybody is great with numbers, great with money management. Some people are better with things like healthcare decisions. Others may be money. And really taking an honest and objective look at members of your family to determine who would be best suited for what role can really save a lot of heartache. It can be sometimes like trying to fit a square peg into a round hole. It's important to really think about who you want to be able to step in, who's willing to do it. Maybe there's somebody who's close by. And maybe somebody who is more familiar with ins and outs of business and finances. Maybe they'll be a better person to handle financial decisions, whereas somebody else may be better at handling medical decisions. Taking an honest look at those people and really figuring out how best it's going to be set up can really help to ensure that things are handled properly, timely, and that you don't have issues in the future. So, an overview of our discussions today. We're going to be looking at powers of attorney first. What are they? What do powers of attorney do? And once they're set up, how do they actually work in practice? What types of decisions can you make, and how do you do that? If you set up a power of attorney, what kind of impacts is it going to have on your daily life, if any? And then what if you want to make a change? Things happen all the time, whether it is family changes, law changes, maybe people that you previously named have moved away. If you need to make a change, how do you do that within a power of attorney document? Last, we're going to be looking at what happens without a power of attorney, and that's where we're going to be getting into guardianship. While they're certainly not exclusive, and it's not only if there's no power of attorney, that's kind of the most common scenario that we see when somebody gets a guardianship set up. And then obviously, how do guardianship actually work as well? So, firstly, what does a power of attorney do? So, power of attorney is a legal document where one person grants another the authority to act on his or her behalf and in his or her place. All right. The person that is giving the authority is known as the principal, and the person receiving the authority is known as the agent. There's other names that are sometimes used, attorney in fact, proxy, surrogate, things like that. Why would you set up a power of attorney in the first place? There's a few kind of common reasons that people use. Firstly, is it protects against sudden incapacity. That could be injury, it could be car crash, fall, whatever it is. If you're out of commission for a few weeks or a few months, whether or not somebody's willing to step in and assist regarding various things that you need to get accomplished is half the battle. But the other half is that those persons also have to have the legal authority to actually be able to step in and assist you. Otherwise, they're not going to be able to actually come in and assist. Number two, difficulty managing things as we age. This is kind of a natural process as we go on. The odds of us needing assistance here and there increases. And whether it is, again, due to something like early onset dementia, or just for, as you see, number three, convenience, where you just want your kids, want your spouse, someone else to be able to assist you with making sure things don't fall by the wayside. Bills are paid, vehicles and homes are upkept, your benefit programs, retirement accounts are all taken care of. You take out those required distributions, all those types of things. And number four is to avoid court proceedings, which ties into guardianship, which we're going to be discussing a little bit later, where if there are no power of attorney documents put in place and something needs to take place, if it really, really needs to happen and there's no other way, you may have to go to probate court to go ahead and get a guardianship appointed. That way, that person can act for you and handle whether it's medical issues, financial issues, or whatever it is for you, since you can't manage it yourself. So when we're talking about powers of attorney, there are two types here in Ohio. They split up those related to healthcare decisions and those that deal with finances. So what types of decisions are covered by a healthcare power of attorney? You have your general medical decisions, whether it's just going in, diagnosis, overall treatment, to the more specific, is this medication proper or another? What about certain types of surgeries? You can have those things covered by a healthcare power of attorney. Healthcare powers of attorney can also cover decisions related to artificial life support, okay? It's not mandatory, but you can do that to ensure that those persons that you trust and that know your wishes are able to step in and make sure that whatever you want to have happen is what takes place. With financial powers of attorney, you have, just like it sounds, decisions related to finances. You have things where somebody can step in and manage your money, any retirement accounts you have, investments, things like that. That person can step in for you and write checks on your behalf, pay your bills, make sure those things don't fall through the cracks. And they also can have the ability to sign contracts, hire lawyers or other professionals as needed if you are unable to do so for yourself. When we talk about using powers of attorney, one of the questions that we address first is, when can you actually use that authority? When does it go into effect? And the first one you see right there is your healthcare power of attorney. And that is, again, where someone that you name, spouse, child, somebody else, is there to essentially step in and make a medical decision for you. All right. Now, the way a healthcare power of attorney works is that as long as you have the ability to make your medical decision, you're making it, and the agent has no power. But if you are unconscious, incoherent, something like that, then the person that you've named, spouse, child, friend, whoever it is, can step in and they can make your decision for you when you can't speak to the doctors yourself. Financial powers of attorney, on the other hand, can work either the same way, where it's ineffective unless you're completely mentally incapacitated. For a financial power of attorney, you're not oftentimes in the medical setting when that occurs. So you may actually have to have somebody take you to see two different physicians to make a finding that you're completely incapacitated. The other way to do it is immediate. So what you can do is this: you can sign a financial power of attorney and grant your agent, your kids, your spouse, whoever it is, the authority to step in and act for you as soon as you sign it. This is useful and probably more common, generally speaking, because it enables you to have family members step in and help you out when it's just getting more difficult. You know, you are not completely incompetent, but it's just getting tough to manage. So a financial power of attorney can address those types of situations as well. Both of these documents, when you sign off on them, can either be notarized or they can be witnessed by two qualified witnesses under Ohio law. What do I mean by qualified witness? Well, as you see right there, the witnesses cannot be related to you by blood or adoption. It cannot be your attending physician, and it cannot be the administrator of a nursing home where you are currently receiving treatment. Other than that, if you want to just go with two witnesses, you can do so, although I generally recommend just using a notary if at all possible. When you talk about healthcare powers of attorney, unless a doctor or hospital or whatever medical provider there is knows about the document, it's not going to do you any good. So one of the things that I always recommend is that once a power of attorney is set up, I say go to your primary care physician, go and register with your local hospital ahead of time and give them copies of these documents. That way, if they have any questions about it, or if they need to send it to their attorneys first for review before they're going to tell you if they're going to honor that power of attorney or not, they can do so in advance and before it's actually needed. The last thing you want to do is have it where it's in the moment where something's really needed and they give you a hard time and they won't honor the document for some reason. So turning it in advance can help avoid those types of problems that we see arise sometimes. Similarly, I say with a financial power of attorney, you would take a copy of that document to whatever financial institutions you use, whether it's bank, investment house, whoever it is, again, to give it to them before it's actually needed. So if they have any questions or concerns, they can address it in advance. So I always recommend when you get a healthcare power of attorney to also get a Hipaa release, okay? Now, Hipaa is a federal law that governs the privacy of your medical records, okay? If there is not a Hipaa authorization, a doctor or hospital, any medical provider can't release your medical information to anyone. Now, Ohio has attempted to satisfy the federal law requirements in some of their, some of their statutes is related to Hipaa. Will it work? Will it not work? Tough to say. Okay. Theoretically, if someone's a healthcare power of attorney, the medical provider may release medical information to them, but you might run into problems. So again, the whole idea between powers of attorney is to put backups in place, put contingencies in there, so that if something happens to you, someone else can step in and help you out when the time comes. We want to avoid any possible problems. Getting a Hipaa release in advance, a separate form, is just one other way to ensure that there's not going to be any problems when your healthcare agent tries to actually step in and act for you. For financial powers of attorney, there are occasions when you have additional requirements before you can act. The most common one that we see is if a financial power of attorney wants to take part in some sort of real estate transaction. Before they can do that, that power of attorney actually needs to be filed with the county recorder's office in order to do so. All right. If it's not going to be valid. They shouldn't let that person actually do anything with that real estate. Okay. Depending what you're doing, there may be other things like that that need to be taking place. That's why it's important just to consult with an attorney and to determine what needs to be done and to make sure that the agent named under your power of attorney can actually do the things that you're wanting them to be able to do for you. All right, healthcare powers of attorney versus a living will. This may be slightly beyond the scope of our presentation today, but I always bring it up when we discuss a healthcare power of attorney because there can be a conflict at law between the two documents. So generally speaking, living wills are probably the most misunderstood document that I deal with in my practice. All right, they get confused with your last will and testament all the time, but it's a very different document. So living wills have a very narrow scope, all right? They deal with decisions related to artificial life support only, and typically more about termination of artificial life support, okay? While there are certain other things you can say, if you have special instructions, for example, about what you want to happen if you are on life support, by the way, as you see there on the fourth bullet point, you used to be able to name organ donation gifts within a living will. The law has changed as of this year, 2021. As of August 17th, those are no longer legally valid and will not be honored. The only way to address organ donation now is through the Ohio State Organ Donor Registry through the Bureau of Motor Vehicles. Once you fill that out, that's where you can address organ donation issues. It's no longer valid in a living will. So generally speaking, when you're talking about termination of life support, a living will says this. If something happens to me, let's say I get into a car crash and I'm taken to whatever local hospital is close by. I'm looked at by two different physicians, probably two doctors I've never met before. If they think that as a result of the crash, I am permanently unconscious or terminally ill, and I need life support, a living will says don't. Or if I'm already on it, turn it off, pull the plug, and let me pass away peacefully. It's a decision that you have made in advance, and nobody else can be involved in that decision. Spouse, kids, nobody else has a say as to what happens with life support. I made the decision, and if these two doctors think I'm permanently unconscious or terminally ill, you're pulling the plug and let me pass. All right. The other way to address that issue is through a healthcare power of attorney. What that says is this: if the same situation arises, you get into a car crash, two doctors think that I'm permanently unconscious or terminally ill, before the doctors can do anything irreversible, like pulling plugs, my healthcare agent, my spouse, my kids, for example, they have the right to have a voice in the type of decision if they choose. And they can say, I'll defer to you, doc. I don't know, whatever you think is best. Or they can step in and go like, whoa, pump the brakes, doc. I don't agree with you. I don't think that mom or dad or whoever it is permanently unconscious. Let's do some more testing or get some specialists in here. Let's give mom or dad a few days or a few weeks and see if things improve. All right, they can do those things. Now, there's no right or wrong as to how you want that set up. Some people don't want to put the type of decision onto a loved one. I get it, right? But here's the danger that people get into. People come and see me all the time, and they have both a living will and a healthcare power of attorney. And there can be a conflict, right? So you've got a living will here that says that if I'm permanently unconscious and terminally ill, nobody can be involved in that decision. Those doctors are pulling the plug. And you got a healthcare power of attorney that says that if I'm on life support, even under those circumstances, my healthcare agent can have a voice in those decisions, right? The way Ohio has resolved that conflict, personally, I think it's backwards. is that when that conflict exists, the living will wins. It supersedes the healthcare power of attorney, and those doctors are going to pull the plug, and nobody else is going to be able to have a say in that type of decision. Okay. Again, if those are your wishes, there's nothing wrong with that, as long as you understand the implications of that legal conflict. Most people don't, and I think most people feel better having someone they trust kind of be a backup against these two doctors who may never have met before. But ultimately, it's up to you. We just need to make sure it's set up properly. Okay. Durability. What am I talking about? Not talking about paper towels, not talking about your dad's old pickup truck. When we talk about durability in the realm of powers of attorney, it has to do with whether a power of attorney is going to be valid once you are completely mentally incapacitated. All right, so the way it works is this. In order to set up a power of attorney, you need to have legal capacity to do so. You have to be mentally with it. You have to understand what you're doing, what the implications are, and things like that. Okay. Once it is set up, a power of attorney is valid as long as you remain legally competent. When you become incompetent, if the power of attorney is not durable, it's no longer valid. Okay. The law prior to 2012 would state this, that if the power of attorney didn't address durability, it didn't say whether or not it was durable or not, it was presumed that it was not durable. Okay. As of 2012, the law flip-flopped, where now it's the opposite. If your power of attorney does not address durability, it's presumed that it is durable. Okay. To a certain extent, it requires a different level of trust, because now your agents are going to be acting for you, and you are not mentally with it enough to even be able to know what's going on. Okay. But they're still going to be able to act for you. Again, there's no right or wrong to that. You just want to make sure you're aware of the implications of how your power of attorney is set up. In some ways, I think that a power of attorney being durable is even more important, because that's when you need help the most, right? If you are completely incapacitated, that's when family members really do need to step in for you. And it's not a matter of just convenience, it's a matter of things really just have to get taken care of. And if you don't have a power of attorney set up, you may be looking at what we're going to talk about next, which is guardianship. So once a power of attorney is set up, how would it affect you in your daily life? Okay. In short, it doesn't. Okay. The principal, again, that's the person who's giving the authority to someone else under a power of attorney, does not lose any rights. Okay. You still retain full rights to do anything that you would want to do, even after a power of attorney is completed. It is additive only. You are saying that I can do everything for myself, but in addition to that, if my spouse, for example, needs to sign something for me, she can also act for me. Okay. You contrast that with guardianship, where the person subject to the guardianship, one who has a guardian, they're known as the ward, they actually lose most of the rights to do things themselves. Not everything, but they lose a lot of their rights. The person under a power of attorney you've appointed, your agent, is available to act in your place if needed. Again, they can do things depending on what you've specified in the power of attorney. They can make medical decisions for you if needed. They can sign documents for you, hire, whomever they need, pay bills, things like that. Now, keep in mind that just because someone has been named a power of attorney and they're your agent, it does not give them free reign to go out and willy-nilly do whatever they want with your things. Your power of attorney is still required at law to act in your best interests in the way you would have wished. And if they engage in improper behavior, there can be very serious consequences, both civil consequences that can be sued, as well as criminal charges that can be filed if someone tries to take advantage of their position as an agent under a power of attorney. I'm going to move this here so we can see. What if we need to make a change to your power of attorney document? So one of the benefits of a power of attorney is that it's very easy to change. If you just want to revoke it, it's as simple as putting something down in writing or letting people know, whether it's the bank, the doctor, the agents, that you are revoking it. As long as you have, again, legal capacity, and that is kind of the wherewithal to know what's going on, you have the legal ability to sign paperwork, contracts, things like that. As long as you have that ability, you can revoke your power of attorney at any time. The most common way that we see this happen is when someone executes a new power of attorney. Maybe, again, you want to make changes, change your agents, change the authority you're granting, whatever it is. New power of attorney documents frequently include a provision where they revoke any prior powers of attorney that were executed. To a certain extent, this is just to keep things as clean and simple as possible. It can get confusing if there's, over the years, 3 or 4 powers of attorney and there's no revocations. There can be conflicts between the documents, and there can be questions about who has the authority to actually do what, and whether or not it's valid anymore. Again, as I said before, if you do make a change, whatever it is, make sure to inform the agents that were named or are named, as well as any place where the power of attorney may need to be used, okay? Banks, doctors' offices, financial institutions, and the like. Okay, and that brings us to guardianship, all right? Guardianship overall covers decisions that are similar to powers of attorney, but powers of attorney are generally a private document, okay? It is something that is executed between the principal and the agent. You turn it into wherever the power of attorney is going to be used at, and that's basically it. Guardianship, on the other hand, goes through the court process, which means it's public record. Anybody can see you are subject to guardianship and can verify those details. While there can be reasons why that may be preferable, sometimes it can also be embarrassing, and some people may want to try to avoid that type of public disclosure of their personal affairs. So when you're talking about the types of guardianship, they actually kind of mirror the types of powers of attorney. You have a guardian of the person, which is similar to a healthcare power of attorney. You're the one that makes medical decisions for your ward. You address things like medication, medical treatment, surgeries, as well as living circumstances. So whether they can stay at home, go to a nursing home, something like that. Guardian of the estate, on the other hand, is the one that handles all the financial aspects. Money management, paying bills, hiring lawyers, other professionals, and signing contracts on behalf of the ward. Why would you choose one or the other? It sometimes can be a matter of necessity. So powers of attorney, as we said, you need to have legal capacity to sign those. You have to have the wherewithal to understand what's happening, what you're doing, to have the legal ability to sign those forms. If a loved one is kind of too far gone to be able to do that, you're stuck with guardianship if something needs to happen, okay? Along those lines, guardianship is sometimes involuntary. You've got a family member who is having difficulty and they can't manage things for themselves, and maybe they're embarrassed about it. Maybe they're in denial and they think that they're fine, but they're really not. Medications are being mismanaged, bills are not getting paid, things like that. Now, there can certainly be times where guardianship is agreed upon, and the ward understand what's happening enough, at least, and they can agree they want their spouse or their kids to take over, but it's not always the case. Whereas a power of attorney is voluntary, and no one can force you to sign a power of attorney for someone else. Going back to court involvement with guardianship, this one kind of cuts both ways, where there are some times where court involvement would be preferable and sometimes not, okay? So the fact that a court is involved in a guardianship means that the court sees everything and has to approve everything before anything takes place. The court is known as the superior guardian, and there are periodic reporting requirements, financial disclosures that need to be made, and any expenses or bills or things that are requesting to be paid out by the guardian have to be approved by the court in advance. This can be preferable if maybe you don't have a local family member that can handle these types of things, and you want someone like the court to make sure that things are being handled properly. The other side of that is that if the court is involved, again, it means it's all public record, and it can get kind of expensive. There are ongoing costs. Guardians can get paid for the work that they do, as well as you have court fees, filing fees that are imposed both at the outset of guardianship and throughout the process. All right. Point number 4 at the bottom there is kind of what we've been saying along too, is that the ward, the person subject to the guardianship, loses the legal ability to do most things on their own. Things like sign contracts, pay bills, write checks, they cannot do for themselves anymore. Again, you don't lose all your rights. Your personal choices like diet, entertainment, religion, even things sometimes like within reason, drinking alcohol or smoking cigarettes, you still have the right to make those decisions within reason. But a lot of other things you actually lose. The guardian has to be the one to actually take care of those for you. I think it's helpful to do a very brief side-by-side comparison of powers of attorney versus guardianship. Number 1, again, powers of attorney are voluntary. If you don't want to give someone the authority under power of attorney, you don't have to. And if you change your mind, you revoke it, you change it. It's very easy to do. Guardianship is not so easy to change or terminate. It can be voluntary. You can say, no, I know I need help. I'm okay with my son or somebody else stepping in to manage things for me. Or it can be involuntary, where somebody thinks maybe they are okay still, and the court is going to be one to step in and make the final decision as to whether or not they are okay. And if they're not, the court can impose a guardianship, even if the person disagrees. Because of that, there are some pretty strict guidelines that need to be followed, because the court is literally taking someone's rights away from them and giving them to somebody else. Okay. The court is very cautious and wants to make sure they only do it when it's appropriate. Number 2, with powers of attorney, there's generally speaking no court involvement. It's a private document. Your agent goes and uses the power of attorney wherever it's needed, and generally speaking, there's nobody else involved. That is, unless there's issues or concerns about their actions, then that would kind of be a separate issue where someone may be what they call breaching their fiduciary duty and acting improperly. But generally speaking, day in, day out, there's no court supervision, no court involvement in those types of actions. Guardianship, on the other hand, as we've said, does involve the court throughout the process. They see everything. They say yes or no to everything, which can ensure things are run properly. Powers of attorney, generally speaking, are pretty inexpensive. They're not much to set up, and the ongoing costs are typically pretty minimal. Guardianship, on the other hand, because of the nature of the process, can get fairly costly. Number 4, under power of attorney, principal retains all of their rights still. They don't lose anything by doing a power of attorney, whereas under guardianship, they do. They lose the ability to handle things themselves, and the guardian acts in some ways kind of like a parent, where they are responsible for making sure that their wards are taken care of, their bills are paid, and all their obligations are satisfied. Number 5, powers of attorney. I'll actually group together 5 and number 6. Powers of attorney are very easy to change or revoke, where guardianship is not. Once the court has it set up, if you want to expand or contract the powers under guardianship, there's some court process and maybe some hearings need to be undertaken. As far as terminating guardianship, it doesn't happen all that frequently. Okay. Once the court is involved in managing someone's affairs, there's generally speaking only 3 ways in which a guardianship terminates. 1, you've got where the ward regains legal capacity. So if it is a temporary situation where they are maybe injured, but they recover, if they recover their competency, they can petition the court to terminate the guardianship at that point. The other way, number two, is if the guardianship ends because the ward has basically run out of money. If there are no finances to manage, there's no point having a guardian of the estate. Okay, you may still have a guardian of the person in certain circumstances, but if there's just not the money available anymore, a guardianship can possibly be terminated under those situations as well. And lastly, if the ward passes away, obviously the guardianship ends at that point. Number 7 is an interesting point that a lot of people miss. One of the shortcomings, in my opinion, of a power of attorney, as a result of the way the law was passed in 2012. So in 2012, Ohio adopted the Uniform Power of Attorney Act. But one of the things that they did not specifically adopt was a provision in there requiring institutions, doctors' offices, hospitals, banks, and the like, to honor a power of attorney. Okay, the Uniform Act had it in there, and we took it out here in Ohio. What that means is this: if you go to a bank with a financial power of attorney, they can take it, review the document, and say, I don't like it. It's too old. It's too short. It's not detailed enough, or no reason at all. Doesn't matter. They can say they don't want to honor it and refuse. And that's the end of the story. They can refuse, and there is nothing you can do. There's not a legal sanction that can be brought against the bank or whoever it is to force them to honor a power of attorney. That's one of the reasons why I think it's so important to make sure powers of attorney are updated frequently, and that they are not some boilerplate or DIY document. You want to make sure you take away any possible reason that the bank or doctor's office can have to say no. Okay. Again, this could be addressed in part by filing them with whatever institution you want in advance. That way you're going to know if they have questions or concerns before those documents are actually needed. Okay. Guardianships, on the other hand, must be honored. A bank cannot refuse. If you are guardian of a ward, you have all the rights to all that person's information, just as if you were the ward themselves. And the bank, the doctor's office, cannot deny you access to those things. Okay. So that can be another pro or con with one setup versus the other. And number 8, kind of as I said a few moments ago, powers of attorney and guardianship both terminate upon the death of the person who set it up. The death of the principal in the case of power of attorney, and the death of the ward in the instance of a guardianship. And this gets confused too. I have clients call me all the time that say, hey, I got one of my parents passed away. I'm their power of attorney. What can I do? Short answer is nothing. Once a power of attorney is in place and someone passes away, the only way to manage things from there, if it's like assets, bank accounts, things like that, unless there is something else in place, like co-ownership, which, by the way, I don't recommend. That's a whole other story. But unless there's something like a transfer on death or a trust or something like that, the only way to actually have the legal ability to manage the assets of someone who's passed away is going to probate court using a will or Ohio's rule of descent and distribution. So all in all, there is a lot to discuss, and we have a very limited amount of time to talk today. So if you have questions or like more information about powers of attorney, about guardianship, these are a few good resources for you. There's the Ohio Developmental Disabilities Council. They put out a lot of good information, including a handbook regarding guardianship itself. Next on the list there is the Ohio State Bar Association. Again, there's a lot of materials available online that discuss both the ins and outs of powers of attorney as well as guardianship. The Supreme Court of Ohio likewise has both some standard guardianship forms, as well as a lot of information about how guardianship powers of attorney work and some of the nuances of those documents. Last but not least, you have your local resources. Okay. Contact your local probate court. The clerks are often pretty helpful in maybe pointing you in the right direction. The probate court is the one that would have this jurisdiction to address issues related to powers of attorney or guardianship. So they'd be the ones to contact specifically. And, don't underestimate the value of going to the library. Local law libraries are going to have a lot of good information. I know the librarians that I've met have all been very helpful in pointing you in the right direction and maybe giving you guidance on some good legal treatises you can use to brush up on some of the details of these documents. At the end of the day, there's really no substitute for qualified legal counsel, but in some circumstances, it helps just to go through and get some general information. With that, we've made it. I thank you for your time and attention. Again, I know there's a lot of information to be given out here, and there's a lot more information coming throughout the week as the presentations proceed with the Financial Wellness Fair. I hope you've all got some good information out of this, and best of luck in the future. If you need anything, contact my office or another local attorney. I'm sure we can be happy to help guide you through the process. Thank you again, and take care.